and welcome to Conversations with Candidates. My name is Bruce Sampson, and I'll be your host. This programming is made possible by the Washington Parish Democratic Executive Committee and the Washington Parish NAACP. The candidate that we'll be talking to in this episode is running for City Judge, Mr. David Merlin Duke. The list of questions that I'll be asking our candidate have been provided by the sponsors. And so without further ado, thank you so much for taking the time out of your busy schedule to be with us today.
I'm glad to be here, Bruce. Thank you.
Great. So we're just going to have a little conversation. I'll ask you a few questions and we'll just take it from there.
Okay.
So my first question is, what is your general judicial philosophy?
I've always tried to go by a theory that if someone knows how to get in touch with me at 10 o'clock at night or can use someone else to get in touch with me, that whatever request that I could assist someone with during that time, that I would also assist everyone else who doesn't know who to begin to call the same way. That's how I've used my position as a prior assistant district attorney and as city prosecutor, and I'll continue to do that as judge, which is in order for me to know that I can put my head on my bed at night, that I'm unchanged by the offices that I've been lucky to hold and hopefully will hold in the future, that what I've done, my scales of justice internally are at level because I've been able to assist everyone equally. And I try my best to do that every day.
Beautiful. Now, do you feel that judges have an obligation to improve public understanding of the courts? And if so, how should they carry out that obligation?
Absolutely, they do. And it's a continuing obligation. It must always be the case where we, certainly for the adult side, where those proceedings are public. On the juvenile side, those proceedings are not public. So, but I'll speak about that in a moment. On the adult side, we absolutely must. One unique position in this judgeship is not only are you the judge, you're also the court administrator. You are responsible for the maintenance and the operation of the office. You have 3 employees, and especially in that arena, we have seen a decline in how that position is held currently, and that's why I'm running to certainly make changes in the administration of the court system so that it's done, that there's budgeting done, that everything's above board, we're not getting sued, and the like. So it's a continuing obligation to run the court and use the modern technologies that are available, which we failed to do currently, and I'm going to bring those to the forefront when I take office. They're not expensive. You just have to do them. As well as educating the public of what is going on in the courtroom. Certainly defendants know because they're subject to it. And then families of defendants might know, and victims know, and families of victims know, but the general public doesn't. And one of the things I would like to do is that the adult court can actually move. We could have a court session at high school, for example, and have set up and run and take minutes there. That's not an impossible thing to happen. You just have to believe that you can move forward and do something different there. And then that would open the doors to let others see what goes on. Of course, the public's invited. It's not the most enjoyable thing to do, so most people don't come see what goes on in court. But on the adult side, most everything is public, unless there would be some reason to seal for sensitive information, but those usually can be done off the record and outside the purview of the court, of the citizens in the courtroom. On the juvenile side, those are secret. Each case is secret, but that doesn't mean the process has to be secret. And there again, I would open the doors to the process and let people know what to expect. I have some ideas in the juvenile arena that I want to implement on day one, and change the way we are operating there as well. So it is a continuing obligation, not just that you did it when you first got elected or you've done it 15 years ago. It is a continuing obligation to certainly let the public know what goes on in court, and also to know that the defendants, if they know what's going on in court, then while they may not be there for someone else's case, they know their case is treated just like everybody else's. And that is something I certainly pledge to bring to the court.
Awesome. Um, so my next question is, if you were to observe a party in your courtroom that you viewed as being poorly represented by an unprepared or ineffective lawyer, how would you handle that situation?
Certainly, the court in that case could continue the matter. They could which would be postponing the matter and giving either the defendant a chance to choose a different attorney. The public defender is always in court when we're there as well. If that's not an option that the defendant wanted to take advantage of, then certainly a continuance or a delay in the proceedings to allow the defendant to choose the counsel of their choice. That is always an option of the court, and I would certainly utilize that. So I would never force an ill-prepared or unrepresented defendant to go to court unless they've had an opportunity once to rectify it. Now, coming back a second time, that might be a different issue. And if the issue is the same, then there might not be a continuance, and we want to try and bring that case to the docket. But most often, certainly a continuance would be in order there. And because as a prosecutor, I've always wanted and hoped that defendants had attorneys. It's much easier for me as a prosecutor to deal attorney to attorney, sometimes especially with sticky issues, than it is with attorney to a non-attorney. And I'm certainly cognizant when I'm dealing with a non-attorney that I'm not using my ability or knowledge as an attorney to beat them over the head with it. I'd much rather deal and have them on an even playing field with me as a prosecutor, and I would want that case, if I'm a judge, that it's also both sides are equally represented before we went forward.
Thank you. What factors are considered in granting and setting bail amounts for defendants?
Bail is an interesting topic. I think oftentimes it's used as a punishment mechanism when really bond, and under my administration, bond would be used to assure appearance in court. And that's the idea behind bonds, is to make sure a defendant appears in court. It's not to make sure that whatever the ultimate fine might be needs to be paid, but the bond is on par with the charges. And so initially, my theory is that bonds need to be set as low as possible to assure the court that the defendant's presence is, that the weight of the attendant's presence is the bond. Nothing more. It doesn't have to deal with the punishment, just that the weight of the bond needs to be that person won't blow off court, but takes it serious enough that they come to court. And that's what bond should be used for, and that's what I'll do.
What alternatives have you used or considered besides sending juveniles to Florida Parish?
Okay. As a prosecutor, my role is I don't have any authority to send anyone to jail, an adult to jail or a child to Florida Parishes. As a prosecutor, I don't make that decision. That's the judge's decision. As a prosecutor, certainly on the juvenile side, the first step is after a case is presented to the prosecutor's office, and in that hat, I had an assistant district attorney hat on. It's to review the case, and if no priors, typically that child would then be eligible for diversion. So it's not even a proceeding that goes before the court. It's handled in an internal diversion program with the DA's office. So that's certainly my first step as it comes to juveniles. As a judge, if I am so lucky that I will consider, first of all, I won't criminalize discipline at school. The school to prison pipeline will be stopped. Discipline should be discipline at school, and crimes are crimes. Now, a fight at school that's a little dust up, no injuries, that probably won't go to Florida Parishes. A fight with a knife or somebody has an injury, that might. But the idea that just because it happened at school, it needs to be handled through Florida Parishes and then the court system is sort of contrary to my thinking. At one time, it might have been the school of thought. I think it's been disproven, and I won't do it. Discipline is discipline, and crimes are crimes. The idea for a judge to what the mechanism that I would use is this child a danger to himself or to others? Is there a safe space that he could go to that night? And if there is, then there's no need to remove the child from those surroundings. And typically, most juveniles appear in court. It's rare. They must appear with their parent, and it's rare that most don't come. So the idea that it needs to be a high bond, and of course a bond for a juvenile can't be a commercial bond. It only has to be the parent's signature or property. But the most part, I don't think I would utilize Florida parishes for minor offenses. The legislature's already seen to it that for a misdemeanor offense, anyone under 13 cannot go. So the trend in the law and in the legislatures is that we should be using pre-trial incarceration much less than we do. And as the judge, I would stay on top of those trends and make sure that I'm following those, and maybe even ahead of the curve, because you can't unring a bell. And by sending a child to Florida parishes, why use your heaviest deterrent for the smallest offense? And I've never understood that philosophy. So if a child has a little dust up at school, to send both to Florida parishes. In fact, when that's happened, I've had the school come, after they've done an investigation, the school comes to me and says, hey, the second child was just defending themselves. Well, at that point, I can dismiss the case, but I can't take away those nights from that child's memory because they were sent to Florida parishes. So pretrial incarceration would be a limited tool for me, and it would really have to depend upon whether the child's a danger to himself or herself or to others, their family, for example, and whether or not there's a safe space for the child to go to. If there's a safe space for the child to go to, then there's no need to remove them from that family setting to go to Florida parishes.
What do you believe are the causes of the high rate of minority incarceration?
Unfortunately, in our small town, one of the things that we lack, and it's hard to say, is hope. A lot of kids especially, and young adults, think that this is all they have. This is their world. There's nothing outside of the city limits, or there's nothing better for them. And that's a terrible thought for me. I grew up here. I went to school here, graduated. I went away to school. I went away and lived other places and decided to come home. I'm lucky to live here. I'm lucky to have a job that lets me live here, and I'm seeking that. I plan to stay here. I don't intend to go anywhere. So I'm invested in Bogalusa and its surrounding areas, and I want to make it a better place. That's why I'm running for judge. But the idea that there are people that think that the only thing they have to do is hustle to make ends meet, or is terrifying to me. And I think that's a problem that we have here, is we have a small town hopeless problem. And I want people to know, and I'm hopeful. And one of the things that, I've given up my largest job, my insurance and my retirement program to run for judge, because I'm not satisfied with the way things are. I would hope people are not satisfied with the way things are. That if we don't constantly strive to be better, if we don't believe we can be better, then we end up in a hopeless situation, and we are content with our surroundings. I'm not content with the way things are here. I want to change that, and that's why I'm running for judge. I can't change everything, but I'm an attorney, and I've been a prosecutor, and I want to be judge. And that's an area where I can make a difference and an influence. And I'll use my position as judge to let kids know that a run-in with the law doesn't define you. You can be better than you were yesterday. All you have to do is hope and believe that tomorrow will bring change. And on November 3rd, I'm asking that everybody vote, because we can make a change in the Bogalusa City Court. It will not change if it's status quo. If you think it's working, then I guess more power to you. But what we have now isn't working, and we must give our kids hope that a run-in with the law doesn't define you. A young adult, a run-in with the law doesn't define you. One of our biggest problems is, of course, drug abuse. And I know that they struggle. I know that it's a devil that's inside of them, that's an addiction that they cannot handle. And that's why some of the things they do, that they do. I want to make sure that as judge, I'm listening to everything, and not only listening, but I'm hearing it, and I'm taking it into the meditation of my heart to know that if I can, I will help and make a condition so that they are better and they know they can be better, not just to be beat down by a system and left after they've completed their sentence that, oh, it goes back to the status quo. If Bogalusa is accepting that now, then we won't be better. But I have to know that we believe in a better tomorrow, and that's why I'm running for judge.
What are your views on whether the court as a whole deals effectively with racial and gender bias?
I think we do deal with those relatively well. One area we don't is we don't deal with socioeconomic very well. If someone can pay a fine, then they have that ability. If they can't pay a fine, the timelines are so short, they often have to choose food and rent, medicine over paying the fine, and then they face jail. And that's something that I won't do. On day one, I'm going to institute a payment plan where you can pay a partial payment. You shouldn't have to be in a position to choose your rent over paying a fine or facing jail time. And I can only imagine, I'm lucky, you're lucky, you don't have to think in those terms. And I can only imagine how someone has to feel when, do they pay their rent, or do they get that medicine, or do they buy their child a school supply so that they can appease the court before they have to go to jail. And that won't happen with me on day one. It doesn't happen in other courts, and it shouldn't happen here. And on November 3rd, if elected, the first day I take office, I'll change that.
Do you have any final words that you'd like to share with the voters? Sure.
Let me speak about day one as me as a judge. I'll institute a 90-day amnesty program so that if you're aside with the court where you have an attachment or you missed a court date due to COVID or any other reason, you can walk in those doors and get a new court date, no problem, first 90 days if I'm judge. Secondly, if you call the court now and tell them you missed a court date, they're going to tell you to go turn yourself into the jail. That'll end on day one as me as judge. I won't do that. We have court every Monday. You come, show up when you're ready to get right with the court, and we'll get right with you. For juveniles, I'm going to end the school to prison pipeline. Discipline will be discipline and crimes will be crimes, but we're not going to send a child to Florida parishes with me as your judge for tossing a pencil in school or for a little fight. I had a fight in 7th grade and it taught me something. Don't get in fights. I didn't get arrested and I didn't get let out from the school in handcuffs. I can only imagine what that would feel like to a child, and I won't do it. Next, if you stood in front of the court and you know that timeline of whether you provide whatever they're asking and you face jail time, we're going to be much more sympathetic to you. We're going to give you time to get the information that you require for the court to be satisfied, and you will not face the threat of jail just because you can't pay a fine. It's not the right thing to do. I'm number 79. I'm David Merlin Duke. I grew up here. I've been here. You can trust me. I will pray every day to do right by you as the citizens of Bogalusa in the 4th Ward. On November 3rd, please consider me. Early voting starts this Friday, October 16th. You can go either to the courthouse in Franklinton or to Votech here in town. But please consider me. I'm number 79. I'm David Merlin Duke. I'm running for judge, and it will only change one way, with your help. Please help elect me judge, City Court of Bogalusa, number 79. I'm going to be a new judge for a new court. Thank you.
Thank you. Again, I thank you so much for your time and for your candidness. And yeah, everyone go vote.
Thank you, Bruce. I appreciate it. Unfortunately, the last day to register was yesterday. So who's registered it's here on out. But early voting does start on Friday. It runs from 8 a.m. to 7 p.m. and every day except those 2 Sundays between October 16th and the 27th. So you're right. You can't. You got to be in it to win it. And so everybody, please go vote.
Thank you so much.
Thank you, Bruce.